Formation of a contract. The formation of a contract is the process by which a legally binding agreement is created between parties through recognized legal elements. To form a contract, there must be an offer, acceptance, intention to create legal relations, and consideration. Offer and acceptance. An offer is a clear and definite promise to be bound on specific terms once accepted, as shown in Carlisle v. Carbolic Smoke Ball Company. Acceptance is the unconditional agreement to all the terms of an offer, as shown in Brogden v. Metropolitan Railway Company. An invitation to treat is an indication that a party is willing to negotiate rather than be legally bound, as shown in Fisher v. Bell. A bilateral offer is a promise exchanged for a promise, whereas a unilateral offer is a promise exchanged for an act, as shown in Carlisle v. Carbolic Smoke Ball Company. A counteroffer is a response that changes the original terms and therefore rejects the original offer, as shown in Hyde v. Wrench. The rule of communication is that acceptance must be communicated to the offerer to be effective, as shown in Tours v. Miles Far East Corporation. The rule of revocation is that an offer can be withdrawn at any time before acceptance, provided the withdrawal is communicated, as shown in Byrne v. Van Tyenen. Intention to create legal relations. Intention to create legal relations means that the parties intend their agreement to be legally binding, as shown in Balfour v. Balfour. Domestic contracts. A domestic contract is an agreement made between family members or friends in a social or household context. The presumption for domestic contracts in regard to the intent to create legal relations is that the parties do not intend to be legally bound, as shown in Balfour v. Balfour. This can be rebutted when the parties are separated or dealing at arm's length, as shown in Merritt v. Merritt. Commercial contracts. A commercial contract is an agreement made in a business or trade context between parties. The presumption for commercial contracts in regard to the intent to create legal relations is that the parties do intend to be legally bound, as shown in Edwards v. Skyways. This can be rebutted when the parties expressly state that the agreement is not legally binding, as shown in Rose and Frank v. Crompton. Consideration. Consideration in a contract is something of value given in exchange for a promise, as shown in Curry v. Meiser. The rules of consideration are adequacy, sufficiency, past consideration, and pre-existing duties. Adequacy means that consideration does not need to be of equal value as long as something of value is provided, as shown in Chappell v. Nessel. Sufficiency means that consideration must have some value in the eyes of the law but does not need to be economically adequate, as shown in Thomas v. Thomas. Past consideration means that something done before a promise is made cannot amount to valid consideration, as shown in Ream Cardle. Pre-existing duties means that performing an existing contractual duty is generally not valid consideration for a new promise, as shown in Stilk v. Myrick. Privity of Contract. Privity of contract is the principle that only parties to a contract can enforce its terms, as shown in Tweddle v. Atkinson. The rule of privity is that a third party cannot sue or be sued on a contract to which they are not a party, as shown in Dunlop Pneumatic Tyre Co. Limited v. Selfridge. Common law exceptions. Common law exceptions to privity develop to reduce the unfairness of the strict privity rule by allowing third parties limited rights in specific situations. These include collateral contracts, where a separate contract exists alongside the main contract as shown in Shanklin Pier Limited v. Detel Products Limited, an agency, where an agent can create rights and obligations for a principal as shown in Dunlop v. Selfridge. Other exceptions include trusts, where a contract is made for the benefit of a third party as shown in Les Affriches Runis v. Leopold Walford, an assignment, where contractual rights are transferred to a third party. Statutory exceptions. Statutory exceptions to privity are mainly found in the Contract Rights of Third Parties Act 1999, which significantly reformed the common law position. The Act allows a third party to enforce a term of a contract where the contract expressly states this or where the term purports to confer a benefit on them, provided they are identified by name, class, or description, as shown in Nishin Shipping Co. Limited v. Cleaves & Co. Limited. However, the parties to the contract can exclude the Act entirely if they clearly state that third-party rights do not apply. Thank you for watching this video on formation of a contract. I'll see you in the next one.